one day somebody does something unspeakable to someone else, to someone you hardly knew, and you do something about it because you can.
From NBC News, the story comes to us. It took just seconds for a routine traffic stop on a Texas highway to escalate into a fatal shooting that left 24-year-old Ashton Barnes bleeding to death in the driver's seat. What happened during those seconds and the minutes prior during the April 2016 incident is now central to a Supreme Court case being argued on this last Wednesday that could make it easier or harder to hold police officers accountable for the use of excessive force. For Barnes' mother, Janice Hughes, 55, who filed the civil rights lawsuit at the center of the case, the oral argument at the high court is the latest stop on a more than 8-year quest for justice on behalf of her only son, who was a black man. Quote, I want out of this that my son was a victim. He was never a suspect, and I need that to be clear. He was a victim from the very beginning, she said in an emotional interview at her lawyer's home in Houston with her 2 daughters and granddaughter by her side. Now, almost 5 years since the death of George Floyd, another black man killed by a police officer, Hughes believes no progress has been made despite the mass protests and calls for social justice that followed. Cops are still doing it. Nothing's changed. Quote, I feel like at some point somebody has to really take this seriously because it continues to happen. And all we get to do is rally and Black Lives Matter and nothing changes, Hughes said. She goes on, nobody's policing the police. That's the point. Nobody's policing the police. Hughes' civil rights lawsuit was dismissed by lower courts on the grounds that no excessive force was used. But the courts made the assessment based only on the precise moment that force was used, based on a precedent adopted in parts of the country, but not to date embraced by the Supreme Court. Hughes' lawyers are now asking the Supreme Court to reject what has been dubbed the moment of the threat doctrine, which could lead to a nationwide ruling that makes clear courts should consider events leading up to the use of force when assessing an officer's conduct. They only look at that moment. Barnes was driving a rented silver Toyota Corolla, which his girlfriend had booked, on the Sam Houston Tollway in West Houston when the incident took place at 2:45 p.m. on April 28, 2016. He was on his way to pick up his girlfriend's daughter from school, according to Hughes. Roberto Felix Jr., a traffic enforcement officer with the Harris County Precinct 5 Constable's Office, it's a local police department, received a report that Barnes' car had outstanding toll violations. Whoa, big felony. He pulled the vehicle over to the left on the median side of the southbound tollway and approached the driver's side. Barnes initially could not produce his license or proof of insurance and told Felix the documents might be in the trunk. At the time, Felix said he smelled marijuana. Although no evidence of any drugs were found in the car. During those initial moments, Barnes turned off the engine and removed the key from the ignition. The fast-moving sequence of events lasted just seconds and was captured on video filmed from Felix's patrol car, leaving exactly what transpired in the vehicle out of sight. Felix asked Barnes to exit the car, but almost as soon as the car door was opened, according to Felix's deposition in the case, Barnes quickly put the key in the ignition and started the engine and put the car in drive. The vehicle started to move forward. Felix stepped onto the door sill, where the door's at, and shouted at Barnes not to move. He then fired his firearm twice, hitting Barnes in the torso, and the vehicle stopped quickly. Barnes died at the scene. The Houston Police Department, which is separate from the Constable's Office and the Harris County District Attorney's Office, investigated the killing with a grand jury finding no probable cause to bring criminal charges. Felix, who has been a police officer since 2004, was involved in another fatal shooting in 2007 according to testimony he gave to a grand jury investigating Barnes' death. Jeff McShann, a spokesman for the police department, said Felix still works there, of course he does, and has not been disciplined as a result of the Barnes incident. Of course not. It's part of the Blue Gang. A review of the shooting found it was justified. He said, quote, they didn't find anything wrong with what he did, said McShann. Felix, via his lawyers, declined to comment. Now, in his deposition, Felix said that although it had initially appeared to be a routine traffic stop, his view changed because of what he interpreted as Barnes' suspicious behavior, such as not having his license and rummaging around the car looking for the rental car agreement. He said, quote, his actions kept indicating to me that he was up to something. Now, at the time of the incident, Felix did not see any signs Barnes was armed, although a gun was later found in the vehicle. Okay? In the vehicle, right? When Barnes restarted the engine and tried to put the car in gear, Felix said he feared for his safety, which is why he jumped on the door and fired his weapon. I'm going to get back to that. Quote, it must have been maybe 2-3 seconds possibly. At that moment, it felt like it was longer than that, though. Now, in Hughes' lawsuit, she claims Felix used excessive force in violation of the Constitution's Fourth Amendment, which prohibits unlawful searches and seizures. She also filed a separate claim against the police department, which is not directly at issue before the Supreme Court. Her lawyers say Felix could have avoided using deadly force by de-escalating the situation and argue that he violated police department policies on the use of force. The dispute reached the High Court after Judge Patrick Higginbotham of the New Orleans-based 5th U.S. Circuit Court of Appeals, which hears cases arising from Texas, reluctantly authored a decision in favor of Felix. He wrote that he was bound to follow the court's own precedents, but he all but pleaded for the Supreme Court to intervene. Most notably, Higginbotham concluded that if he weren't bound by the moment of the threat doctrine and was able to evaluate a broader array of evidence, he would have concluded that a constitutional violation had taken place. Did you hear that? You guys hear that? Quote, here, given the rapid sequence of events and Officer Felix's role in drawing his weapon and jumping on the running board, the totality of the circumstances merits finding that Officer Felix violated Barnes' Fourth Amendment right to be free from excessive force, Higginbotham wrote. Texas-based District Judge Alfred Bennett had similar concerns when he ruled in March of 2021 that based on the appeals court precedent, no constitutional violation occurred. Like Higginbotham, Bennett criticized the appeals court's approach, saying that it had effectively stifled a more robust examination of the Fourth Amendment's protections when it comes to encounters between the public and the police. It is already extremely difficult to mount a successful lawsuit against police officers alleging excessive force. How the court rules will not drastically change the legal landscape in that regard, but it will nevertheless have a national significance. That is because the 12 regional federal appeals courts are divided, with 4 embracing the moment of threat doctrine and 8 rejecting it, according to Hughes' lawyers. If the court rules for Hughes, the doctrine would be voided nationwide, constituting loss for police officers accused of excessive force. But if the court rules for Felix, it could make it even harder for plaintiffs to bring such claims. Felix's lawyers say that lower courts are not divided on the issue, as Hughes' legal team has argued. They say the approach taken by the Fifth Circuit was consistent with how the Supreme Court has directed the lower courts to address excessive force claims, including under a 1989 case called Graham versus Connor. The Supreme Court said in that case that when determining whether excessive force was used, courts have to view the incident from the perspective of what an objectively reasonable officer would have done in the same situation. In essence, the dispute boils down to what exactly the Supreme Court meant in the 1989 case, building on a ruling from 4 years earlier when it said courts should consider the totality of the circumstances in assessing an officer's actions. Hughes' lawyers say that should include the sequence of events leading up to the use of force, while Felix's lawyers say it should be limited to the exact moment the officer decided to use force. And it goes on from there. It's pretty lengthy. I'm not going to read the rest of it. But a couple of things here. One, these judges are bound to make their rulings based on what happened at the moment use of force was used. That's what they're saying. They're bound to, we have to look at what happened right when the use of force was used. We can't go back and say, okay, what happened leading up to it? This happened, this happened, this happened, this happened, and then boom, he uses force. We can't do that. We got to move all that back and just look at the moment the use of force was used, which is unfair because all those moments leading up to could prove excessive use of force, but they're not allowed to do that. And then the last thing I want to get to, this cop, I feared for my safety, so I jumped on the moving car and then shot him. And he got away with it. And twice he's had shootings. But that's what gets me. I feared for my safety, so I jumped on the moving car and shot him. I didn't back away and go, whoa, whoa, whoa. Yeah, usually when I fear for my safety, I run into the street and stand in front of moving cars. Yeah, because I'm afraid of getting hit. Right? But we'll see what the Supreme Court says. This ruling could, this is the Supreme Court, and this could change everything for use of force cases.